Take it off." Judge Calvin Mercer did not raise his voice. The microphone carried those words across the guardianship courtroom, past the court reporter, past my mother-in-law, and straight to the wheelchair beside me. I stood in Marine Corps service dress blues. The Navy Cross was pinned above my left breast pocket. I had come directly from a memorial service for Gunnery Sergeant Luis Ortega, and brass polish still clung to my gloves. The old scar beneath my right shoulder, left by the same operation as the medal, had begun to ache under the wool jacket. "Rain always found it before I did," Mercer pointed at the medal. "This court will not be influenced by military decoration." Across the aisle, Linda Hale lowered her eyes and pressed a tissue beneath them. The tissue was still folded into a perfect square. My husband, Adam, tapped one finger against the tablet mounted to his wheelchair. The device took a second to catch up, then its electronic voice filled the room. I asked her to wear it. Mercer looked toward Adam without really looking at him. "That device stays silent until counsel calls you." Jonah Price, the attorney appointed to represent Adam, rose halfway from his chair. "Your Honor, that device is his voice." Mercer's jaw moved once. "Then his voice can wait." That was when I understood the hearing was not only about whether Linda could control Adam's medical care and the settlement from the truck that nearly killed him. The man deciding my husband's future had already mistaken slow speech for an empty mind. My attorney, Maya Ortiz, touched my sleeve. She was asking me not to react. I did not. "Is that an official order of the court?" I asked. Mercer leaned back. "Yes, Major Hale, remove it. Then I ask that the court reporter preserve your exact words." The keys began clicking. I unclasped the Navy Cross and placed it beside Adam's tablet. The metal touched the black case with a small metallic click. Linda smiled before she remembered to look heartbroken. She believed the metal had been my advantage. She did not know Adam had answered questions she had never bothered to ask, or that her lawyer had sent Mercer an order before the hearing began. To explain how we reached that room, I have to go back 11 months, to the night a patrol officer called. My name is Rebecca Hale, though almost everyone who knew me before the Marines still called me Becca. Adam never did. He said Rebecca sounded like someone who could argue with a storm and make it apologize. We had been married 11 years by then. He was a structural engineer who trusted numbers, distrusted slogans, and could fix almost anything except the kitchen faucet he had promised to replace for 3 consecutive summers. I worked in crisis management for a shipping company after 18 years in uniform. Most days, the hardest thing I handled was a delayed container or an executive who confused urgency with importance. Adam knew about the Navy Cross before our first date because my mother had mentioned it at church. He never asked how I earned it. Months later, when I finally told him part of the story, he listened without interrupting, then asked whether I wanted the porch light left on when I woke from bad dreams. That was Adam. He did not admire the parts of me other people could display. He paid attention to the parts that needed somewhere safe to land. Linda had never understood that kind of marriage. She was Adam's mother, 67, widowed for 8 years, and still convinced that every room had an invisible seating chart with her name at the center. She had sold real estate around Richmond for most of her adult life, which meant she could make an invasion sound like a courtesy. "I was in the neighborhood," she would say after driving 40 minutes without calling. Or a mother notices things, just before explaining why our furniture, finances, or holiday plans disappointed her. She did not shout. Linda preferred concern because concern gave her permission to enter places anger would have kept closed. For years I treated that as the price of peace. Adam loved her, and I had spent enough of my life watching families break under pressure. So I answered politely. I changed subjects. I let small insults pass because I believed restraint was a form of protection. That was my mistake. Silence can keep a room calm, but it can also teach the loudest person that no boundary exists. The only time Adam directly challenged her was after we completed our estate documents. He had signed a durable power of attorney and an advance medical directive naming me as the person he trusted to act if he could not speak for himself. Linda read the summary page at our dining table. Her thumbnail tapped the paper 3 times. A form should not decide who gets my son if something happens. Adam folded the document and slid it back toward me. It doesn't, he said. I do. Linda laughed as if he had made a joke. 3 years later, at 9:14 on a wet Thursday night, a patrol officer called my phone and asked whether I was related to Adam Hale. Behind his voice, I could hear an ambulance door slam. A loaded delivery truck had run the red light at the intersection near our house. The faucet was still leaking. The emergency department smelled like bleach and coffee left on a burner too long. A nurse met me near the double doors and asked for my name twice, though I had already shown her my license. Adam was in surgery. I put one hand against the wall until the floor stopped tilting beneath me. Linda arrived 20 minutes later wearing bedroom slippers under a wool coat. She took one look at me and asked, "Who signed consent?" I did. Her mouth tightened. "Of course you did." There are moments when anger would be easier than restraint. That was one of them. But a trauma surgeon was walking toward us, and I did not want the first argument of the night to be louder than the news he was carrying. The truck had struck the driver's side hard enough to fold the frame inward. Adam had a fractured pelvis, 2 broken ribs, and a traumatic brain injury. The bleeding in his skull had been controlled, but the doctor warned us that recovery would not move in a straight line. Understanding and speech do not always return together, he said. Do not assume silence means absence. Linda nodded before he finished, the way people do when they are waiting for their turn to speak. For 9 days, Adam did not open his eyes. I learned the rhythm of the intensive care unit. The soft alarm that meant a sensor had slipped. The sharper one that brought 3 nurses running. The housekeeping cart that squeaked every time it passed room 12. I slept in a vinyl chair with my boots beneath it because some habits survive retirement. Linda came every morning with flowers, even after the nurses explained that flowers were not allowed. She left them at the front desk and told anyone who listened that rules had become more important than compassion. On the 10th morning, Adam opened his eyes while rain traced thin lines down the window. He did not know where he was. He knew me. His huge fingers moved against the blanket. I put my hand beneath them and he squeezed once. Linda leaned over the rail. "Adam, honey, it's Mom." His eyes shifted toward her. She began asking questions faster than he could process them. "Do you know what happened? Are you in pain? Do you want me to call Pastor Jim? Should we move you somewhere better?" The monitor climbed. I placed one hand between Linda and the bed. One question at a time. She stared at me as though I had struck her. "You don't get to control how I speak to my son." Adam's pulse kept rising. The nurse asked Linda to step outside. That became the first story Linda later told the court. In her version, I had thrown a grieving mother out of her son's hospital room. She left out the monitor, the nurse, and Adam's hand tightening around mine. Weeks passed before he could communicate beyond yes and no. A speech therapist brought a laminated alphabet board and taught us to wait after each letter. Waiting was the hardest part for Linda. The first full message took Adam 11 minutes. He pointed to H, then O, then M, then E. After a rest, he added W-I-T. His hand shook before the final word. B-E-C-C-A. Home with Becca. I looked at the therapist because I no longer trusted my own face. Linda stood near the sink holding a paper cup so tightly the rim bent inward. 2 days later, an attorney for the trucking company called. Liability was clear, he said. The settlement could reach several $1,000,000. Linda did not ask whether Adam would walk again. She asked who controls that money if he can't. Linda began with brochures. Heritage Haven Neuro Recovery occupied 60 acres outside Charlottesville. The photographs showed cedar walkways, private rooms, therapy pools, and smiling families standing beneath trees that looked too placed to be real. They specialize in cases like Adam's, she said. I read everything before answering. The program was licensed, expensive, and 3 hours from our house. It offered 24-hour care, but only a few hours of therapy each week. Family visits required approval. Weekend leave was limited. I still drove there. The lobby smelled like lemon polish and artificial pine. A woman in pearls called patients' residence and spoke about settlement management before she asked what Adam could do. On the tour, I noticed a row of wheelchairs parked outside the activity room while a television played to no one. I asked how often patients returned home. The woman smiled. Families sometimes overestimate what home can provide. That answer stayed with me. Adam's neurologist recommended a different plan. We converted the downstairs office into a bedroom, widened one doorway, hired a rehabilitation nurse, and scheduled physical, occupational, and speech therapy at home. I built a binder for medications, exercises, invoices, and every decision Adam made. Linda called it military theater. You're running him like a unit, she said. No, I told her. I'm keeping records. She visited often, but she did not like the rules Adam's therapist had established. One question at a time, 10 seconds before repeating it. No touching the tablet unless Adam asked. Linda filled silence because silence frightened her. When Adam searched for a word, she supplied one. When he reached toward a letter, she moved the board closer to the answer she expected. If his response disagreed with her, she blamed fatigue. One afternoon, she arrived with her phone already recording. Adam had insisted on trying to stand without the transfer belt. His knee buckled, and I caught him under the arms before he hit the floor. I told him sharper than I meant to, that he could not make that decision without the therapist present. Linda filmed the last 12 seconds. She did not film Adam laughing after I lowered him into the chair. She did not film him typing, "You sound like a drill instructor." She kept the part where my voice was raised. Later, Maya would find that clip attached to Linda's petition under the title Aggressive Control Incident. At the time, I only asked her to stop recording. A mother should know what happens when no one else is watching, Linda said. Adam reached for his tablet. It took him almost a minute to type the sentence. "Stop filming me." Linda looked at the screen, then at me. That is not him talking. Adam's fingers went still against the edge of the tablet. The rehabilitation nurse, Marisol, turned away from the medication cart and watched Linda without touching the medication tray. I asked Linda to leave. She did, but first she placed a Heritage Haven brochure on the kitchen counter and smoothed it flat with both palms. During the next month, she stopped arguing with me directly. She called Adam's doctors and asked whether I attended every appointment. She requested bank statements from our settlement attorney. She contacted Marisol's agency and asked how often I left the house. Then she began canceling visits unless Adam would see her alone. I kept offering supervised time with the speech therapist present. She called that isolation. The trucking company's settlement proposal arrived in early spring. $4,800,000, structured to cover care, equipment, lost income, and future therapy. Linda spoke about the settlement as though control of it were part of caring for Adam. She asked who would approve the house, the equipment, every major expense, and whether a guardian could reimburse family travel and caregiving time from the settlement. When the attorney told her Adam's existing documents still governed those decisions, she stopped asking questions. 3 weeks later, a process server stood on my porch holding a thick white envelope. Linda had petitioned the circuit court for emergency guardianship and control of Adam's finances. The brochure was still on the counter. Adam had drawn a line through the photograph of the front gate. The petition was 43 pages long. Linda accused me of isolating Adam, manipulating his communication device, refusing appropriate care, and exploiting his condition to control the settlement. She also included a paragraph about my combat history. Mrs. Hale's military conditioning, it said, may be incompatible with patient-centered caregiving. I read that sentence twice while the refrigerator clicked on behind me. The allegations were false, but that paragraph had another purpose. It was meant to turn the most disciplined part of my life into proof that I could not be gentle. Adam watched me from his chair. I read the petition aloud because I would not discuss his future over his head. When I finished, he stared at the tablet, then he typed 4 words. She did not ask me, not she is lying, not I hate her. She did not ask me, that was the point Linda kept avoiding. Guardianship was supposed to protect a person who could no longer make decisions. Linda had built her case by pretending difficulty speaking was the same as inability to choose. The emergency hearing was scheduled for 12 days later. If Linda won temporary guardianship, she could suspend my medical authority, approve Adam's transfer, and ask the court to place the settlement under a conservator. The order would be temporary, but temporary decisions can harden before a family understands what happened. I called Maya Ortiz that afternoon. Maya practiced guardianship and elder law from a narrow office above a bakery in Richmond. She wore red glasses on a chain and kept a brass bell on her desk because, she said, people lied less when something cheerful was nearby. She read the petition without interrupting. When she reached the military paragraph, she removed her glasses. They are not asking the court to evaluate your service, she said. They are asking the court to mistake your service for a diagnosis. Then she turned to Adam. Mr. Hale, my job is not to prove your wife is a good person. My job is to make sure the court understands that this is your life. Adam nodded. Maya gave us 3 priorities. First, an independent specialist had to evaluate Adam without me in the room. Second, every financial accusation had to be answered with records, not outrage. Third, we needed to discover why Linda had selected Heritage Haven before any court had found Adam incapacitated. You do not win these cases by making the other side look cruel, Maya said. You win by showing the judge what the least restrictive option is. That phrase mattered. Least restrictive. A court did not have to choose between total independence and total control. Adam could use supported decision-making, a durable power of attorney, and professional help without surrendering every legal choice to a guardian. My grip loosened around the petition. I opened the care binder. Maya looked at the color-coded tabs, therapy notes, medication logs, and receipts. You built this before there was a lawsuit? I built it because mistakes cost him progress. She nodded. Good answer. The financial review took 4 days. It showed that I had spent more than $62,000 of my savings on renovations, equipment, and uncovered therapy. His account had paid only documented medical and household expenses. The settlement money had not been disbursed. Dr. Priya Shah conducted the neurological evaluation. She asked me to leave the room. For 90 minutes, I sat beneath a sailboat print and listened to a clock scrape instead of tick. Linda had spent months saying Adam's answers came from me. If I stayed, every correct response would become another accusation. So I stayed outside. When Dr. Shah opened the door, she did not smile. Your husband has expressive impairment, she said. He does not have an empty mind. Her report found that Adam understood the case, recognized the consequences of each option, and consistently chose me as his agent. Full guardianship, she wrote, would remove more rights than his condition required. 2 days later, the court appointed Jonah Price to represent Adam independently. He met Adam alone. When he came out, he buttoned his coat and said, he knows exactly what everyone is trying to take from him. Then Discovery produced the first document Linda had not expected us to see. The document was a preliminary placement agreement between Linda and Heritage Haven. It had been signed 6 days before she filed the guardianship petition. Under the agreement, Adam would be transferred within 24 hours of Linda receiving temporary authority. An affiliated company would manage the settlement and approve major expenses. The attached fee schedule showed that residential charges and Dominion's management fees could reach 16% over several years. On a settlement of $4,800,000, hundreds of thousands could be removed before Adam bought another wheelchair. On the second page, beneath Linda's signature, someone had written, "Judge expected to move quickly." Maya studied the line. "Do not assume that means Mercer," she said. "We prove what we can prove." The attached email chain was worse. Linda's lawyer had sent a proposed emergency order to the judge's chambers before Adam's attorney was appointed. The judicial assistant had replied, "Received. Revised language discussed." Maya printed the message twice. One copy went into our exhibit binder. The other went into a sealed envelope for a possible motion asking Judge Calvin Mercer to step aside. That night, after Adam fell asleep downstairs, I sat alone at the dining table with the petition, the care binder, the placement agreement, and the email spread beneath the yellow light. The faucet leaked once every 11 seconds. My coffee had gone cold beside my elbow. I drew 3 columns on a legal pad. What Linda claimed, what the record showed, and who could verify it. Blocked visits matched cancellation messages. Missing money matched receipts. Unsafe care matched instructions from Adam's therapists. Then I placed Keene's proposed order beside Mercer's temporary scheduling order. The same paragraph appeared in both, so did the same misspelling of accommodation. I circled it once and slid a yellow tab beneath the page. By 1:13 in the morning, the petition no longer looked frightening. It looked measurable. Linda had written a story. I had kept the record. The morning of the hearing began at Quantico. Gunnery Sergeant Luis Ortega had died from cancer the week before. He had been one of the Marines lifted from a landing zone I helped hold 9 years earlier, during the operation that led to my Navy Cross. His widow asked me to attend the memorial in uniform. I nearly said no. The medal spent most of its life in a cedar box beneath our bed. I did not wear it to restaurants, family gatherings, or arguments. Adam joked that I treated the decoration like an embarrassing school photograph. That morning, he watched while Marisol helped fasten my jacket. When I reached for the wooden box, I stopped. The courthouse was 40 minutes away. I could change in the parking garage, but the hearing had been moved forward, and traffic was building. Adam typed with his left hand. "Wear it," I asked why. He looked at me, then typed, "You never left us. The memorial ended late." By the time Maya called, I had 19 minutes to reach the courthouse. I drove there in service dress blues, parked beside a delivery van, and entered security with brass polish still on my gloves. Judge Mercer noticed the medal before he acknowledged Adam. Linda's attorney, Martin Keene, stood and said my appearance created an unfair emotional influence in a case involving military trauma and caregiving. Maya rose. "My client came directly from a memorial service. Her uniform is properly worn, and no witness has been asked to draw any conclusion from it." Mercer looked at me. "Take off the decoration." There was no anger in his tone. He spoke as though correcting the position of a chair. Maya asked for the legal basis. Mercer tapped his pen against the bench. "I control this courtroom, counsel." I felt the old instinct to answer pressure with precision. It had kept people alive once. It could also turn a courtroom into a contest nobody needed. So I asked one question: "Is that an official order of the court?" "Yes, Major Hale, remove it." "Then I ask that the court reporter preserve your exact words." The keys began moving. Adam touched the tablet mounted to his chair. I asked her to wear it. Mercer turned toward the sound. "That device remains silent until he is called." Jonah Price stood. "Your Honor, the device is not an accessory. It is how my client communicates." "Then your client can communicate through counsel." Jonah stayed standing. "With respect, that is not communication. That is substitution." Mercer looked directly at Adam. Not long enough to wait for an answer, he told Jonah to sit. I unclasped the Navy cross, the pin caught in the fabric near my pocket. The delay embarrassed me more than the order. I set the medal beside Adam's tablet. Its blue ribbon crossed the black case. Linda lowered her face into a folded tissue, but her eyes stayed dry. Maya asked the court reporter to read the order back. Mercer frowned at her. "Counsel, the record speaks for itself." "Then there should be no harm in confirming it." The reporter read each word. "Remove the decoration. This court will not be influenced by military decoration." Adam listened closely without moving. Mercer called Linda as the first witness. She described me as rigid, controlling, and damaged by combat. She said I had blocked access to her son, refused professional care, and trained Adam to repeat answers through the tablet. Then Martin Keene played the 12-second video from our living room. My voice filled the courtroom. "You cannot make that decision without the therapist here." The clip ended before Adam laughed. Linda looked at the judge as though the case had already been decided. Mercer wrote something on a yellow pad. Maya waited until he put down his pen. Then she stood with the visit calendar in one hand and Marisol's sworn statement in the other. The medal was off my uniform. The first lie in Linda's petition lasted less than 3 minutes. Maya began with the visit calendar. Every date Linda claimed I had blocked access had a note beside it. Therapist present, nurse present. Linda cancelled. Linda requested private visit. Adam declined. Marisol's statement explained why she had been asked to remain during visits. Linda interrupted instructions, moved the alphabet board, and answered questions before Adam could finish. Martin Keene objected. Mercer overruled him without looking pleased. Maya handed Linda a copy of the schedule. "Can you identify a single visit, Mrs.?" Hale refused. Linda turned 2 pages. She made the conditions impossible. What condition was impossible? I should not need supervision to see my son. That was not my question. Linda's tissue lost its square shape. She admitted I had offered visits. She admitted the speech therapist had recommended structure. She admitted Adam had sometimes asked her to leave. Then Maya moved to the money. The settlement funds had not been paid. Adam's checking account showed no unexplained withdrawals. My own account showed payments for the widened doorway, the shower conversion, the transfer equipment, and therapy the insurer denied. The independent accountant had traced every transfer for 14 months, including the $27 pharmacy charge Linda had circled in red and labeled suspicious. It was Adam's prescription copay from the hospital pharmacy. Maya placed the total on the screen, $62,400. Linda looked toward Martin Keene. He did not look back. Mercer asked whether the number was disputed. Keene said no. Mercer looked from the total on the screen to the receipts in front of him. Linda folded the damaged tissue into a smaller square and kept her eyes down. Dr. Priya Shah took the stand after lunch. She explained Adam's condition without softening it. He has expressive aphasia, she said. His language output is impaired. His comprehension, judgment, and ability to form preferences are not erased. Keene asked whether a spouse could influence someone using a communication device. Anyone can influence anyone, Dr. Shah replied. That is why I evaluated him without his wife present. She described the examination, randomized questions. Repeated concepts phrased differently, choices involving consequences rather than simple preferences. Adam had identified his physicians, explained the purpose of the settlement, recognized the risk of institutional placement, and consistently selected supported decision-making over full guardianship. Mercer leaned forward. How long did these answers take? Some took several minutes. Does that not suggest uncertainty? Dr. Shah adjusted the cuff her sleeve. No, it suggests patience is part of the accommodation. No one moved until the court reporter finished typing it. Jonah Price asked that Adam be permitted to answer directly. Mercer allowed it, but ordered everyone to avoid leading questions. Adam's tablet was turned so the screen faced him alone. Jonah started simply. Mr. Hale, do you understand why we are here? Adam typed, to decide who controls my life. The electronic voice sounded flat. The words did not. Jonah asked what would happen if Linda became temporary guardian. She can move me. We're Heritage Haven. Do you want to go there? No. Who do you want to help you make medical decisions? Rebecca. Why? Adam paused. His finger hovered over the keyboard, then moved again. She waited. I lowered my eyes to the table. Linda made a sound behind her tissue. Jonah continued. Do you believe Rebecca controls your answers? No. Did she prepare what you are typing now? Did anyone tell you how to answer? No. Keene stood for cross-examination. He asked Adam whether he loved his mother. Yes. Whether Linda had cared for him as a child. Yes. Whether he understood she was afraid. Adam looked at Linda for a long time. Yes. Keene glanced at the judge, then asked the question he thought would help. If your mother is acting from love, why would you refuse her help? Adam's hand stopped. The courtroom waited. Had typed one word, erased it, and began again. Love does not cancel my answer. Keene's face tightened. He asked whether I had told Adam Heritage Haven was dangerous. Adam typed. She took me to visit. That had been Maya's decision. We had arranged a supervised tour after the petition was filed so Adam could see the facility himself. Keene asked what Adam disliked. Locked doors. Many medical facilities have controlled access. Adam typed again. They spoke to Rebecca about me while I was there. Mercer shifted in his chair. Keene moved to another subject. He suggested the power of attorney had been signed before Adam understood the possibility of serious injury. Jonah objected that the document had been executed years before the crash. Mercer allowed the question anyway. Keene asked, who decided Mrs. Hale would act for you? Adam pressed the final letters slowly. I did. No one spoke over him. Maya requested admission of Dr. Shah's report, the financial review, the visit records, and Jonah's independent statement. Mercer admitted them. Then Maya turned toward the clerk. Your Honor, we are ready to address the proposed placement and the communications with Chambers. Linda stopped touching the tissue. Martin Keene closed the folder in front of him. For the first time that day, he looked afraid of his own paperwork. Maya lifted the red exhibit binder we had assembled. It contained 186 pages of care logs, financial records, independent evaluations, correspondence, and public filings. Each tab answered one claim Linda had made. Maya opened the binder and placed the Heritage Haven agreement beneath the document camera. The plastic cover struck the glass with a flat click. Linda's signature appeared on the courtroom screen. For 1 second, the only sound was air moving through the ceiling vent. Maya touched the date with one finger, page 82. Your signature, 6 days before the petition, she asked Linda when she first contacted Heritage Haven. Linda said she did not remember. Linda adjusted her glasses. I was exploring options. Did Adam authorize you to sign this? It was preliminary. That was not my question. Linda looked toward Adam, then away. No. Maya turned to the fee schedule we had already traced. Heritage Haven would charge for residential treatment. Dominion Care Management would oversee the settlement and approve major expenses. Together, the projected fees could reach 16% over several years. Maya placed a calculation beside the agreement. $4,800,000 appeared at the top. Hundreds of thousands in projected care and management fees appeared below it. Linda stopped smoothing the tissue. Maya asked who had explained those fees to Linda. A representative, name, Elaine Porter. The clerk marked the agreement and calculation as exhibits. Next came an affidavit from the state licensing office. Heritage Haven was authorized to provide residential rehabilitation, but Dominion Care Management was a separate private company. Neither had been appointed by any court to manage Adam's money. On the screen, Heritage Haven collected the residential charges. Dominion controlled the approvals. Adam's name appeared only in the paragraph describing the assets and care decisions they would manage. Martin Keene rose. There is nothing improper about planning for care. Maya nodded. Planning is not improper. Concealing the plan from the person being placed is. Mercer told her to avoid argument. She moved to the email. The message appeared on the courtroom screen. Keene had sent a proposed emergency order to Mercer's judicial assistant before Jonah was appointed. The subject line read, Hale Matter, Revised Language. Maya asked Keene whether he sent it. He admitted he had. Did you copy Rebecca Hale's counsel? No. Did you copy Adam Hale's appointed attorney? There was no appointed attorney yet. Did you notify Rebecca Hale? No, Keene said proposed orders were routinely sent to chambers. Maya agreed, then she enlarged the reply received. Revised language discussed. What revised language was discussed, she asked. Keene said he could not recall. Maya placed Mercer's temporary scheduling order beside Keene's draft beneath the document camera. The pages slid against the glass. A paragraph authorizing evaluation at Heritage Haven appeared word for word in both documents, including the phrase medical transport as necessary and the misspelling I had circled the night before. Maya pointed to the two lines, same paragraph, same misspelling. The court reporter stopped typing for half a second. Somewhere behind us, a pen cap clicked and did not click again. Mercer closed the folder before Maya finished citing the page. This proves nothing beyond administrative handling. Maya reached for the sealed envelope, then disclosure should resolve it. Inside were public records from Heritage Haven Foundation. Judge Mercer's wife, Caroline Mercer, had served as honorary chair for 3 galas. Photographs showed Mercer accepting an award from the foundation. Travel disclosures listed 2 conferences, but the donor line was blank. A separate filing from Heritage Haven listed the expenses as charitable outreach. Maya did not accuse him of taking a bribe. She asked whether he had disclosed the relationship to either side. Mercer's voice changed. My wife's civic work has no bearing on this case. Jonah stood. It bears on my client's confidence in the tribunal, Your Honor. Mercer told him to sit. Jonah remained standing long enough to say, I join the request for disclosure and recusal. Keene's chair creaked as he shifted toward Linda. Linda leaned toward him and whispered, You said he knew. Keene's hand covered the microphone at their table, but the court reporter had already looked up. Maya asked for 3 things: preservation of all communications between Chambers and Keene, suspension of the hearing until those communications were reviewed, transfer of the matter to another judge. Mercer denied all 3. He said the email was administrative, his wife's role was ceremonial, and the court would not be manipulated by insinuation. Maya asked permission to recall Dr. Shaw for 1 question. Mercer allowed it. Dr. Shaw returned to the witness chair. Did Heritage Haven contact you about Adam? Maya asked. Yesterday. They requested his medical file and said his transfer had already been approved. Mercer looked at Keene. Keene looked at Linda. Linda said they told me it was standard preparation. Dr. Shaw held up the release form. It carried Linda's signature as guardian. She was not Adam's guardian, not yet. Dr. Shaw turned the release so the signature faced the court. Linda's name sat above the word guardian. The placement agreement was already in evidence. The licensing affidavit had established who would collect the fees. Now the release showed Linda using authority the court had not given her. Maya asked that the form be marked. Mercer held it for several seconds, then admitted it. He set it beside the other exhibits and reached for his pen. The court is prepared to rule. Linda straightened, set the tissue beside her folder, and looked toward the clerk. Mercer announced that he found serious conflict in the home and insufficient assurance that Adam's preferences were free from influence. He appointed Linda temporary guardian for 10 days, suspended my authority, and approved an immediate evaluation at Heritage Haven. Maya requested a stay, denied. Jonah requested one. Denied. Adam's tablet spoke before anyone could stop him. Do not let them take me. Mercer signed the order. Mercer's order gave Heritage Haven authority to collect Adam from the rehabilitation clinic before 5 that afternoon. It was 2:12. Maya did not argue in the hallway. She opened her laptop on a bench beneath a vending machine and began replacing blanks in an emergency appellate petition she had drafted the night before. You expected this? I expected a judge who refused disclosure might refuse a stay. Jonah joined us with the order. He had already called the Court of Appeals clerk and asked how to submit an emergency request before close of business. Nothing about the next 3 hours felt heroic. We scanned exhibits through a machine in the courthouse library. The feeder jammed twice on Dr. Shaw's report. A clerk said one attachment had the wrong file name. Maya corrected it beside a trash can full of coffee cups. The petition asked for an administrative stay. Maya attached the transcript of Mercer ordering me to remove the Navy Cross after the capacity report and the documents showing that the transfer was already being arranged. The records prove Adam can choose, she said. The transcript proves Mercer had already decided which voices counted. The medal order was not the emergency by itself. It connected the private paperwork to the judge willing to enforce it. The central documents were still the ones that protected Adam. Dr. Shaw's independent capacity report, Jonah's statement that Adam opposed the transfer. The medical release Linda had used as though she were already guardian. The undisclosed Heritage Haven agreement, the email between Keene and Chambers. The order denying recusal. At 3:20, Heritage Haven sent a transport team to Adam's rehabilitation clinic. Marisol called from the nurse's station. Behind her voice, I heard a vehicle backing toward the service entrance. They have 2 attendants and a stretcher, she said. The order looks valid. The appellate clerk had asked Maya for proof that the transfer was not merely possible but underway. Marisol photographed the intake sheet before an attendant removed it from the counter. Linda was listed as court-appointed guardian, and the clinic's timestamp showed that Heritage Haven had begun acting on the order. Maya added the photograph to the petition while I drove. The clinic administrator checked the seal and nodded. It was valid. A bad order still carries legal force until another court stops it. I drove to the clinic while Maya remained at the courthouse. Jonah followed in his car. Neither of us discussed what would happen if the appellate court did not respond. Linda was already there. She stood beside Adam's wheelchair with a leather folder under one arm. The Heritage Haven attendants were checking straps on the stretcher. Adam's tablet rested on his lap. Home, it said when he saw me. Linda stepped between us. You no longer have authority to interfere. I stopped several feet away. The old part of me measured the room without permission. 2 exits, 1 security officer, a transport cart blocking half the corridor. None of that mattered. I could not remove Adam by force without proving every accusation Linda had made about me. So I sat in the plastic chair across from him. I'm here, I said. His hand shook above the screen. Do not promise. He knew me too well. I won't. For 40 minutes we waited while Linda signed intake forms. She talked to the attendants about room placement and visiting hours. She did not ask Adam a single question. At 4:11, one attendant unlocked the wheelchair brakes. My phone remained silent. I remembered another place where I had waited for aircraft beneath a darkening sky. Back then, waiting had meant holding ground until the last wounded Marine was lifted out. Here, holding ground meant staying in a chair. At 4:18, Jonah's phone rang. He listened, asked the caller to repeat the case number, then handed the phone to the clinic administrator. The Court of Appeals had entered an administrative stay. Mercer's transfer order was suspended pending review. My authority, under Adam's existing documents, remained in effect until another judge could hear the matter. The attendant released the strap. Linda's pen rolled off the folder and struck the floor. No one moved to pick it up. Adam typed slowly, put it back. I knew what he meant. The Navy Cross was still in Maya's evidence pouch. She arrived 20 minutes later, carrying the stamped stay and the medal. I pinned it to my uniform in the clinic hallway, not for Mercer. Not for Linda, for the man who had asked me not to leave. That evening, after Adam was home, Maya filed a judicial conduct complaint supported by the transcript, the email, the order, and the appellate stay. The complaint separated each role: Linda's unauthorized signature, Keene's private draft, Mercer's undisclosed relationship, and the company's position to collect. We did not complain before the misconduct occurred. We waited until the record could speak. The new guardianship hearing took place 3 weeks later before a different judge. She reviewed Dr. Shaw's report, spoke with Adam directly, and rejected Linda's request for full guardianship. Adam kept his durable power of attorney, along with a supported decision-making agreement that allowed him to choose professional help without surrendering his legal identity. Linda was ordered to pay part of our attorney fees. Heritage Haven was barred from contacting Adam unless he initiated it. That should have ended the story. It did not. The Judicial Conduct Commission began with Mercer's courtroom remarks and the undisclosed email. Then investigators requested his calendars, travel disclosures, and prior guardianship orders involving Heritage Haven. 7 months passed. Adam continued therapy. I returned to work 3 days a week. Every Thursday, Marisol made cinnamon toast during speech exercises because Adam pronounced hard consonants more clearly when he was complaining about burnt edges. Life became ordinary in small pieces. Ordinary did not mean easy. It meant our hardest days no longer introduced themselves before breakfast, and that was progress. Then a local reporter called Maya. Public records showed Mercer had appointed Heritage Haven or Dominion Care Management in 38 contested cases over 6 years. His wife's foundation role was not merely ceremonial. The organization had paid for 2 conference trips, 4 gala weekends, and an award dinner where Mercer described Heritage Haven as the gold standard for vulnerable adults. None of those relationships appeared in our case disclosure. Other families came forward. One woman said her father had been transferred before she received notice of the hearing. A retired teacher said Dominion fees consumed nearly 1/5 of her brother's estate. A former clerk provided emails showing Keene had submitted proposed orders through private channels in several cases. Our hearing had not created the pattern. It had left a record clear enough for investigators to see it. The commission found that Mercer had failed to disclose conflicts, permitted one-sided communications, and repeatedly entered emergency orders without giving affected adults a meaningful chance to participate. Investigators identified 11 private order chains, 9 transfers authorized with less than 24 hours of notice, and 38 contested cases tied to Heritage Haven or Dominion. The Navy Cross incident appeared in the findings, but only as evidence of temperament and bias. He had treated a lawful military decoration as manipulation, while dismissing Adam's communication device as an inconvenience. The deeper violation was visible in every number. Mercer had decided whose voice mattered before the hearing began. On October 14th, the commission filed formal charges and suspended him from new guardianship assignments. On December 2nd, the state Supreme Court removed him from the bench. On January 9th, the state bar suspended his license to practice law. He also lost his judicial committee positions, his public speaking appointments, and the reputation he had built around protecting vulnerable people. I did not attend the disciplinary hearing. Adam watched part of it online, then closed the laptop before Mercer finished speaking. Enough, his tablet said. Linda's agreement with Heritage Haven was referred to state regulators. Dominion returned $1,180,000 in disputed fees collected from 9 estates. Martin Keene faced his own professional review after investigators documented 11 private order chains carrying his drafts. People later told me Mercer had lost everything. That was not quite true. He still had a home, a pension subject to review, and people who loved him. What he lost was authority. There is a difference. Losing everything makes a person a victim. Losing authority because you abused it is accountability. By then, Linda had stopped calling me. She began sending letters directly to Adam. For 3 months, he left them unopened beside the cedar box that held my medal. Then one morning, he typed a sentence I had not expected. I want to see her, not forgive her, see her. Linda chose the rehabilitation center because it was neutral ground. She arrived 10 minutes early and sat with both hands around a paper cup she never drank from. The room had pale walls, a round table, and a clock that ran 2 minutes slow. Jonah was there because Adam had asked him to attend. Marisol waited near the door. I sat beside Adam but kept my hands in my lap. Linda began before anyone invited her. I was scared, she said. You had doctors, lawyers, binders, schedules. I felt like I had no place left. Adam looked at the tablet, she continued. Heritage Haven promised I would be included. They said I could help make decisions. I thought if I waited, Rebecca would shut me out completely. My name sounded like an accusation, but I did not answer. Adam typed, "You did not ask what I wanted." Linda leaned forward. "I knew what you needed." His fingers stopped. For several seconds, the only sound was the air vent above us. Then the tablet spoke. "You knew what made you feel necessary." Linda's cup bent beneath her grip. "That is cruel." Adam shook his head. "You wanted authority, not my safety." She looked at me then. "Did you teach him to say that?" Jonah answered before I could. "No, he asked me to help him prepare for this conversation." Those are his words. Linda's face changed, not dramatically. The muscles around her mouth simply gave up holding the expression she had brought into the room. "I am still your mother," she said. Adam typed more slowly. "Yes, then, that does not make you my owner." Linda covered her face. For years, she had treated Adam's pauses as empty space she was entitled to fill. Now she had to sit inside one. He told her he would not discuss finances or medical decisions with her. Future visits would happen only with a therapist present. Letters could continue, but he would choose whether to answer. Linda asked how long those rules would last. Adam looked at the screen. "Until I trust you." She nodded once. There was no reconciliation. Not that day. Some damage does not close because the truth finally arrives. It only becomes visible enough that everyone must stop pretending it is small anymore. When she stood to leave, the cup remained on the table with a crescent pressed into its side. Marisol threw it away after the door closed. Adam leaned back, exhausted. "Too much?" I asked. Then he added, "My choice." I placed my hand beneath his. For most of the case, I had believed protecting Adam meant standing between him and anyone who might take control. That morning, I understood the harder version of protection. Sometimes you step in, sometimes you step back far enough for the person you love to draw the line himself. A year after the hearing, Adam walked 26 steps with a cane across the rehabilitation gym. He still used the tablet when fatigue tangled his speech. He still hated cinnamon toast with burnt edges. I still woke some nights when trucks braked on the road outside our house. Recovery did not return our old life. It gave us a different one. On the anniversary of Luis Ortega's memorial, his widow invited us back to Quantico. I laid my service dress blues across the bed and opened the cedar box. The Navy Cross looked smaller than I remembered. For months, I had associated its weight with Mercer's courtroom, with the sound of a judge deciding a symbol on my chest mattered more than the man beside me. I reached for civilian clothes. Adam rolled into the doorway. He looked at the uniform, then opened his tablet. "Not for the judge." I waited, for us. He helped me fasten the medal, though his fingers still moved slowly. The pin caught in the same place it had in court. This time, neither of us rushed. At the memorial, no one announced my name or told the story behind the cross. We stood with Luis's family beneath a gray sky while a bugler played taps. Adam held my hand through the final note. That was enough. Peace was not victory music. It meant standing beside him without deciding which direction he faced. The Navy Cross never proved I was a better wife, and it never gave me the right to speak for Adam. It reminded me of an older promise: do not abandon someone because reaching them has become difficult. People think abandonment means leaving. Sometimes it means staying close while quietly replacing another person's choices with your own. Linda had called that love. Mercer had called it protection. Adam called it what it was: control. The first time I wore that cross, it marked the people I refused to leave behind. The day Mercer ordered me to remove it, I learned that silence is not consent, delay is not confusion, and dependence is not surrender. Adam had never been voiceless. Powerful people had simply preferred not to wait for him. Judge Mercer thought the medal was influencing his courtroom. In the end, it was his refusal to listen that cost him the robe. If this story stayed with you, tell me which moment changed the way you saw Linda, Mercer, or even Rebecca. Share it with someone who needs the reminder that dependence is not surrender and silence is not consent. And subscribe to Quiet Reckoning for more stories about people who reclaim their voice without losing their dignity. Mercer did not lose his home or his family. He lost everything the robe had allowed him to control.